Hi, I'm Attorney Virginia Hunt, talking to you about Nevada workers' compensation law. So, last time we talked about the overall appeals process, and today I'm going to talk to you about people who want to do it themselves at the hearing officer level. People who have not yet decided to hire an attorney think that maybe they can go it alone, and remembering that the Nevada Attorney for Injured Workers doesn't come into play until the next level of appeals at the appeals officer level. So your choices are either to do it yourself or to find a private attorney to represent you when you have to go to the hearings officer level. So here's a few tips for doing it yourself. And keep in mind, about 2 weeks, I'm going to be posting another video that actually takes you to the hearings officer room and shows you what the configuration is and what to expect when you get there. But right now, let me give you a few tips on how to present your case. The first thing is make sure that you file your request at the right place. File it with the hearings division within 70 days of receiving that adverse determination letter from the adjuster. Attach the letter that you're appealing to that request for hearing form and make sure that it gets received by the hearings division within 70 days. There are very few excuse provisions there, so it must be received there. Secondly, you need to understand that it's only that particular issue that the hearing officer is going to want to hear about. That particular issue on appeal. Let's say you contest the average monthly wage determination letter. Don't go into other issues about what the doctor said and how you want to change a physician's, because each issue has to be filed on its own, each determination letter. So make sure that you stick to the point. Thirdly, if you need additional medical records, for example, they're closing your claim, you need to go to a doctor and get some additional medical reporting that says you need additional medical care. It's not going to be sufficient for you to go in there and tell the hearings officer that you disagree with that doctor. It's going to be much more persuasive if you go to a doctor on your own and you have a report in hand you can give to the hearing officer. So get your medical evidence or whatever other documentary evidence that you need ready for the hearing officer. Now, most of the time, attorneys presenting their case will have done a hearing statement which attaches the evidence, and they get that to the hearing officer ahead of time. But you're not expected to be that sophisticated in terms of how we do things legally. So, but make sure you get that evidence with you. You can attend the hearing by person or in phone, but make sure that the hearings division has a good phone number for you and that you are available. Hearings do not go exactly on the time that you're advised on the notice of hearing. If they're scheduled at 9 o'clock, it means that there could be 6 hearings scheduled at 9 o'clock, in which case your hearing may not take place until 9:45. So beware of that and be ready to expect that. Be professional when representing yourself. You are not convincing the attorney on the other side who represents the insurance company, nor are you trying to convince the adjuster at that level. You're trying to convince a hearing officer. So you want to be pleasant and you want to be professional. And expect the hearing to go quickly. You only have about 5 minutes to present your case, so stick to the issue and the important points. Be aware that the hearing officer does not ordinarily rule right there after the hearing. The hearing will conclude, you'll leave the hearing officer room, and then you'll get a decision about 14 days. So thanks for visiting, and be sure to look for this upcoming blog when we actually go to the hearings office.